Hello and welcome to episode 79 of the Study Legal English podcast. I am your host Louise and today we are looking at civil appeals. Before we get started, I'd like to say that this episode is sponsored by italki, a platform where you can find many native English teachers online. Sometimes my students ask me, what are the best courses for learning legal English in the UK? Now, there are quite a few very good courses, and these courses are really great if you're able to take a week, 2 weeks off work, and you can afford to travel, and as well, of course, pay for accommodation because these courses are not cheap. A really good alternative, if you can't do this, is to take classes online. You can schedule classes to fit around your busy working day, and for the same price of a 1 week legal English course in the UK, you could take one class a week for a whole year with online classes. And of course, with your online classes, you get a teacher who is your own teacher who's dedicated to improving your legal English needs. So if you're curious to check out italki, you can get $10 worth of free credits when you purchase your first italki class. If you go to go.italki.com/study legal English, I will leave the link in the show notes. So in the last episode, I asked listeners, how do parties in your countries go on appeal? How do they appeal a decision? I had a message from Virginie who said that in France, parties have the right to a second hearing and parties can challenge the judgment, the decision of the court of first instance on both findings of fact and the application of law. In order to appeal a decision, the party who wishes to appeal must file a notice of appeal with the Court of Appeal in the same jurisdiction as where the dispute was decided at first instance. Then, if the parties are still not satisfied, they can go on appeal to the Court of Cassation. But here the court just reviews whether the law was applied correctly. They don't retry the case. They don't question the facts. So thank you, Virginie, for sending in that answer. It's quite interesting to find out how things work in other countries. And now we will be looking at how parties can appeal decisions in England and Wales. So let's get started. If a party is not satisfied with a decision made at first instance, they may wish to appeal. In the majority of cases, in order to go on appeal, the party wishing to appeal must seek permission first. When will the court grant permission to appeal? Permission will only be granted where the court considers that the appeal would have a real prospect of success, or there is some other very strong reason why the appeal should be heard. For example, the case is of great public importance. On what grounds can a party appeal? An appeal must be based on relevant grounds. This means the reasons for appealing. The general rule is that an appeal court will only allow an appeal against a decision that was either wrong because the judge made an error related to the interpretation or application of law, or it was unjust because the judge made a very serious procedural mistake. The appeal court is unlikely to allow an appeal based solely on a question of fact, where a whole new re-examination of the facts would need to be taken. To be clear, a question of fact relates to the circumstances of the case. For example, whether the defendant did or did not indeed deliver the goods to the claimant on a set date. That would be a question of fact, what actually happened. And a question of law would be about how the judge interprets and applies contract law to this case, how the judge interprets the contract between the parties and then applies it to the facts to determine whether indeed there was a breach of contract in this instance. So, how do parties seek permission to appeal? The party wishing to appeal can ask for permission in two ways. Firstly, the party can ask for permission to appeal from the court of original jurisdiction at the end of the hearing at first instance, where the decision to be appealed was made. Or, secondly, if the party does not seek permission from the original court, or permission is refused by that court, then he or she can seek permission, can ask for permission from the appellate court by lodging an appellant's notice with such court. Generally, this court is the next court up in the hierarchy. So, for example, a High Court decision will be appealed to the Court of Appeal, and a Court of Appeal decision will be appealed to the Supreme Court. So, what information should be included in the appellant's notice? When filling out the appellant's notice, the party wishing to appeal must write specific details about the original claim and also about the appeal. The details to include are the claim number, the name and details of the claimant and defendant, the name of the judge who heard the case, the name and contact details of the appellant and respondent, the details of any legal representation, the legal representatives who will represent the parties in the appeal, the grounds for appeal, this is the reasons for appeal, and what the party is asking the appellate court to do. For example, to set aside the court order, to change the court order, or to order a new trial, a retrial. There are also a number of documents which should be filed shortly after the appellant's notice, including 3 copies of the appellant's notice and 3 copies of the grounds of appeal, 1 copy of the skeleton argument in support of the appeal or the application for permission to appeal, and a skeleton argument is a document which gives very brief details of each argument the appellant intends to argue in the appeal hearing. And as well as that, they may have to include a copy of the approved transcript of the original judgment. There are very strict time limits which parties must adhere to. For example, the appellant's notice must be lodged with the court within 21 days of the original hearing. A court fee must be paid when the party does this, and following this, relevant documents must be served on the respondent or the respondents within 7 days after the appellant's notice is filed. So if you're curious to know what an appellant's notice looks like, it can be accessed and downloaded from the UK government website. I'll leave a link in the show notes. What happens if permission is granted? If permission is granted for the appeal, then the appeal will of course eventually be heard. This usually takes place before a 3-person court made up of judges who are known as Lord or Lady Justices. Usually, no new evidence is allowed because the facts have already been determined and decided at the first instance stage. However, sometimes it is possible to file fresh evidence with permission of the judge. As is the case at first instance, judgment may be given immediately on the spot, although it may also be given at a later date. And according to Part 52 of the Civil Procedure Rules, that is the part which governs appeals, the appellate court has the power to do a number of things, including to affirm, set aside or vary an order or judgment made or given by the lower court. They could order a new trial or hearing, and they can make a costs order. The general rule is that the unsuccessful party pays the costs of the successful party. However, the court has great discretion as to the terms of payment. What happens next? If one of the parties is still not satisfied with the outcome of the case, then there may still be the option of further appeal. A party may be able to appeal to the Supreme Court. However, it must be said that permission to appeal to the Supreme Court is almost always refused, because the case to go on appeal to the Supreme Court must be of very great importance. Great, so that brings me to the end of the episode. I hope you've enjoyed listening and you found it useful. As always, members get access to benefits which they can find on the Study Legal English website, studylegalenglish.com. If you enjoyed listening today, then why don't you subscribe to the YouTube channel? You can subscribe to the podcast on iTunes, and you can really help me out by leaving a review, which helps others know why you like the podcast. So I'm taking a short break in August, but I will be back in September with many more podcast episodes. I wish you all a great August. If you're taking a holiday, I hope you have a nice break, and I'll see you all soon. So thanks for listening and see you next time.